Oscar Kambona. Oscar, you are most welcome to the Parliament of Lawyers. I was told not to say the Parliament of the Bar. You're most welcome to the Parliament of Lawyers.
Thank you, Elson. Thank you for hosting me. And I'm glad to be here this evening and share with the colleagues and members of the public what I know about tax and answer your questions. So I look forward to the discussion this evening.
Thank you, Oscar. If you're just joining us, we've been joined by Dr. Oscar Kambona. And Oscar, I think the first question we shall ask you is a question we ask all our guests who come. So, you know, on this space we have hosted many people. This thing began because we were trying to contest for an election in the legal space, but owing to backlog, we are still here waiting for a decision. I think the first question we ask all our guests, and what people really want to know, people are asking, who is Oscar? Who is Dr. Oscar Kambona? What makes him tick? What makes his heart beat faster? His blood boil hotter? His mind race faster? I forgot to say that, by the way, Oscar is a health freak. He only eats nice things, and then he runs from here to Nairobi. But Oscar, who is Oscar Kambona, and what makes him tick?
Thank you for that kind introduction. It is said that a person is who he is when nobody is watching. So there is the Oscar the people see, but there's Oscar, the inner part of Oscar. So in answering that question, I will try and separate the two, but also try and be brief, because this question of who you are is a very deep question. So there is Oscar the persona, the person called Oscar. And that person, the outer Oscar, is, as you described me in the kind introduction, a lawyer in the first place, went to school at Makerere, did law, graduated in 1994, went to LDC, graduated in 1995, so started practice in 1996. So this year I celebrate 30 years in practice. So in that respect, yes, practiced specifically in taxation, but of course having some inroads in other areas. But as you explained, I am a founding partner at Kampala Associated Advocates, where I head the tax practice. Oscar is also a parent. He loves exercises. He loves sports. Some friends of mine call me an exercise addict. I love running. Running, marathons in particular, and badminton. And for the last 6 years, I was the president of the Uganda Badminton Association of Uganda. Yeah, so, I mean, Oscar, a former teacher, a lecturer at LDC for 16 years. So that's the Oscar that the outside world sees. But there's the Oscar, the inner Oscar, the one that, when you remove all those titles, the one that remains, that's the inner Oscar. So who is he? Yes. Now that Oscar is a student of life. He's a student of life. That Oscar is the student of life. I am a seeker of truth. I want to know the truth. But I'm also a seeker of knowledge. One of my values is knowledge, because I believe in continuous learning. I believe that you can't know everything. So in this discussion this evening, you'll hear a lot about learning and the need to learn. I'm spiritual, not necessarily religious, but very spiritual. I am value-driven. I believe in values and principles guiding my trajectory. And in that respect, I am part of a readers' table, a book club in Uganda. I think one of the largest book clubs in Uganda, known as the Readers' Table. We sit every week. But the purpose of that book club, and which speaks to my spiritual side, is that we seek to transcend our limitations. We seek to transcend life's limitations. Life has got limitations. By the fact that a human being, there are certain things you won't know. But in reading, you try and understand some of those limitations. And some of that explains why at an old age, after 30 years of practice, I decided to go back to school. And we'll speak more about that. But yes, a seeker of knowledge, a seeker of truth, and spiritual in that respect. Yeah, so briefly, that is who Oscar is. It's something that we can discuss a whole evening, but I'll summarize it in that context. Thank you.
Ladies and gentlemen, you've heard it here. A student of life, a seeker of faith, a seeker of knowledge. Oscar Kambona, Dr. Oscar Kambona. It's, you know, Oscar just became a doctor last week, the week before last week. So I think we are really coming to terms with the title. Now, Oscar, maybe if you're just joining us, we are hosting Dr. Oscar Kambona. He has just told you from his legal career that he was the first cohort of LDC, the first group of enrolled lawyers to practice under the new constitution. Is that in 1995? So he's many of the people who we have been hosting are people who still have a 1967 mentality. But so you're one of the modern lawyers. Oscar, you're also a founding partner of Kampala Associated Advocates, which is KAA, the law firm where we both work. And many people have been asking if you could take us back to the beginning. How did the firm start, and what was really the vision? What was because it has become an institution. I know some people are very happy to hear me say this, but it has become an institution. And what was your vision? Tell us about the start, the formation of KAA. Very briefly, if you could tell us the KAA story.
The short answer is that KAA started in 2001. So that's when it started. But the discussions started earlier. And to better understand the history behind KAA, you have to go back a bit back and understand the context, especially of the founding partners who started KAA. That will explain the vision and the objectives that informed the idea and the decision to start KAA. So I'll start with myself. I leave LDC in 1995, and 3 months later, I'm called upon by the director to come and start teaching at LDC. So I go through the process and then I start teaching. But I start teaching because our year was the first year to study revenue law and taxation at session. And then because the lecturer then at LDC was teaching taxation was an accountant, when we qualified and I completed, I was asked to start teaching taxation. So I start teaching and at the same time decide to focus on taxation. So instead of starting a law firm, I decide to start a tax bureau that specialized in taxation. So I called it the Uganda Tax Bureau. So I had my practice, fairly successful at that point in time. And then I get a call. I get a call from the Attorney General then, who was Honorable Bart Katurebe, and he says he would like to have a meeting. I had met him at LDC when he came as a guest of honor. He came as a guest of honor during our graduation, and I happened to receive a prize during that time, and so we chatted and ended up that we were coming from the same constituency. So anyway, he calls me and tells me, I want to leave government, but I'm not interested in even running as a member of parliament anymore. I want to go in legal practice. And he says, I have had a chat with a colleague of mine who had called him, and that person was Honorable Eli Karuhanga. Honorable Eli Karuhanga then was the member of parliament of Nyabushozi, and he was the chair of the presidential and parliamentary committee. He too had decided that he wanted to leave politics. But he had a law firm called Karuhanga and Company Advocates, fairly successful, by Ugandan standards. But he had a different vision. He felt that the Uganda we were going into under the new constitution was a Uganda that you had to look at the bigger picture. So he had contacted Katurebe, Justice Katurebe, who became the Chief Justice eventually, who then contacted me, who was now practicing in taxation, purely under Uganda Tax Bureau. And then also contacted Honorable Sam Mayanja, who's now currently the Minister of Lands, State for Lands, who also had just left Uganda Development Bank, where he was the corporation secretary, and had started a firm called Mayanja and Company Advocates. So you have 4 people who have different practices, except Justice Katurebe, who was coming from Attorney General. And we are now coming together to put together what we call a one-stop law firm. Why? Because you now have Oscar with taxation, you have Sam Mayanja with banking and corporate, you have Honorable Eli Karuhanga with the law firm that was dealing in litigation and government advisory and governance issues. Then you have Justice Katurebe, Honorable Katurebe, who was now Attorney General, having represented government in very many cases. So you have 4 of us. But there was another person. There were actually 2 other people who were in the background. One of them was Honorable, the current Attorney General, Chiriowa Chiwanuka. He actually attended the first few meetings we had, and eventually continued and started with Edwin. But we had some meetings with him, so he was in initial planning stages. But the other person was Peter Kabasi. Peter Kabasi was the Solicitor General at that time, but he had a contract, and his contract had a year to go. So he couldn't leave at that point in time. But the understanding was that when his contract ends, he will then join us. And subsequently, when he left, he joined KAA. Now, why do I give you all this background? I'm giving this background because at that point in time, law firms were fragmented. You had, all these successful firms, Katende Sempewa, Seba Lule, but here we are. We wanted a firm where you will walk in. If your problem is taxation, Oscar is there. If your problem is governance, Justice Katurebe is there. So that one-stop center, and that's the vision we had. But there's another aspect that I would like to mention. We also realized that some of our clients, especially me, who had some of these international clients like Shell, BAT, we realized that these people were always asking us to share some of our opinions and proceedings with international lawyers. So they always had some international side to it. And it was important to also bring in that international side, which was not in existence at that point in time. And that's how KAA, when it is formed, decides to go into partnership with an international law firm known as Denton's. In fact, it was Honorable Karuhanga who got in touch with Denton's, and they come in as a collaborating partner, not as part of the firm. So KAA starts in 2001 you have the four of us all together, merged into one. All our stuff, everything was merged. Our accounts were all merged into one. And then you have the international side of it, where you now have the international brand attached. Later on, of course, like I say, the rest happened. You have now many law firms now with associations with international firms. But lastly, another key milestone. Our problem was now the firms in existence were titled the partners' names. So what do we do here? Do we call it Katurebe, Karuhanga, Kambona, Mayanja Advocates? We said no. Our vision was this must grow. You had people like Kabasi who are coming in 1 year later. What do? We had the vision of having a big law firm. Not only in numbers, but also in terms of practice areas. So, what do? We decide that we shall use a generic name. And I can assure you we had pushback. The question was, no. Kampala, are you the only Kampala lawyers? Why are you calling yourself associated lawyers? But the point was, for us, if tomorrow, and as it happened, if you have a gentleman like Joseph Masiko, who then was the director of civil litigation in the Ministry of Justice, if he wants to join, how are you going to add his name? How is it So we brought about the use of generic names. And that's how KAA was formed, using a generic name, and as they say, the rest is history. Yeah, so that's the history that starts, okay, you want a global outlook, you have a firm that provides solutions, and provides solutions in under one roof, a one-stop law firm. Yeah.
Thank you, Oscar. Thank you for just joining us. Welcome to the Judicial Service Conversations. I must also inform people that the tagline, "Consider it solved," is from Oscar. It is. Maybe still, I'll just... colleagues will realize my conflict of interest, and I will certainly use this conflict properly, and I declare the conflict, and I'm going to use it with shamelessness. But the firm is now recognized as one of the leading firms, Oscar. And looking back, what impact would you say that KAA as a firm has had on the development of law and of legal practice in Uganda today?
Part of that has been answered in terms of starting with the generic name. As we all appreciate now, most law firms use generic names. So in that sense, there was some bit of impact. But importantly, something I want to highlight is that at the back of our minds, and especially myself, speaking of myself, the question was, yes, practice is a service. Practice helps you as a career. You can earn from practice. But the question is, how do you impact community? How do you impact society? And so the question was, if you are to impact society, how do you do that? This tagline you mentioned, "Consider it solved," was in the sense that there are people out there who have legal issues. There are people who out there who want to do commercial transactions. When those transactions need legal input, we should provide that solution. So whoever had the problem and approached us, that problem was considered solved. So in terms of impact, one, beyond the generic name, is that we have participated in several groundbreaking cases that have helped enhance jurisprudence, but also find solutions to pressing problems. Speaking of taxation, for example, I remember getting involved in what you would call one of the largest in terms of monetary value cases, and that was Talo versus URA. A brief, without going into the details of that case, but just to highlight the point of impact and how you help find solutions society, is that Talo, Talo had entered an agreement, a production, what they call production sharing agreement, with the government of Uganda. And in that agreement, they had agreed, the government had agreed with Talo that when Talo eventually farms down, and that's a technical word, but when they eventually sell their interest to someone else, there would be no capital gains tax. That was in the agreement, not denied by government. In the agreement, not amended. So when Talo eventually sold its shares, it's in the production fields to Total and Sinok, URA comes with an assessment and says, wait a minute, you have to pay tax. How much? $345 million. $345 million. I cross-checked, and there was no dispute at that point in time, which was that amount in Uganda, which had been litigated in Uganda. The question was, therefore, you have an agreement that clearly exempts the company from tax. You now have an assessment. What do you do? Of course, they approached us, and we decided that we should find a solution to this dispute. So we filed an objection. The objection was dismissed, and then we filed in the tribunal. But the point I raised this is that we were faced with a situation where, yes, you want to litigate, but at the same time, you want the oil production to progress. Whatever was being done to progress, and this was holding back because these investors were saying, wait, how do we believe in your government tomorrow if you are now reneging on what you had agreed? So what happened is that we entered negotiations, and our focus was a win-win. How could we get a win-win? How can we get government to take something, and how can we get Talo to save something? And I am happy to report that this is one of the cases where we found an amicable settlement. Talo had also filed a case in the international arbitration in London. So we entered an agreement where government was able to receive about $152 million, and the rest was set aside. So in terms of finding solutions, I think KAA has provided that. In terms of setting the trend, KAA has provided that. But there's another interesting point, and that's why I face this gentleman called Elison. Elison subsequently joined KAA. He had his law firm with Zuleika, but decides to join us because we actually approached him and said we want to strengthen, because our point, and this is the point I want to emphasize, our point was, don't look at the little monies involved here. Look at the bigger picture. You can have as many, and our target was you can have as many as 30 partners. Look at the bigger picture. Bring in as much resource and work together and grow the farm. And that's how Elson joins in. Not only do you grow by bringing in other people from other farms, but by also what you call organic growth. And that's how we then eventually promote some of the junior associates. People like Bruce, people like Jet, people like Augustine Idot. We organic growth. And for me, this is very important as lawyers, because one of the things that has been said and is common is where you find lawyers complaining of being exploited and opting to start up their own law firm. So you have very many fragmented one man, two men, women law firms. The idea is no, consolidate. The bigger the better. And for me, as from my experience, one of the greatest inputs towards success of any law firm is the skill. It's not the only. There are other aspects like skill, like ethics. Skill, ethics. There is connections, the connections you have, and knowledge. But skill is very important. So the lawyers, you expose them, bring them together, work together, grow the firm, offer one-stop service center service, and the rest will be history. The money will come, the money will follow the work, but at the core of it is that, yes, as a firm, our target was to create impact, and I'm happy to report that we have done so. And we continue. It's work in progress.
If you're just joining us, welcome to the Judicial Service Conversations. And we've had impact. I needed those points to be made really at the start of the conversation. And but I think Oscar, you make serious points about growth. Well, the legal industry suffers a problem of growth, about vision, about cooperation, about working together, and I think it's absolutely fantastic. And I think those are broad points which have been made. So if you're just joining us, welcome to the Judicial Service Conversations. We have a fantastic guest today, and I think I will hand over the next question to Alfred Muyaka. I always introduce Alfred, Oscar. Alfred is, and many of our listeners are tired of the introduction I make of Alfred. Alfred is the Deputy Secretary General of the East African Law Society, but he is in charge of the young lawyers. But he has, since we started running, he has also been in charge of the young lawyers. So I don't know how young Alfred still is. I don't know now if he's the oldest young lawyer or if he's a young lawyer, but he's also a commercial lawyer, but people believe he's a Chibanja lawyer. This is what people believe, but he's a commercial lawyer as well, and he's one of really our co-hosts here on the Judicial Service Conversations. Over to you, Alfred.
Thank you, the lawyer's lawyer, and I'm glad to be hosting Dr. Oscar today. If you have just joined us, you have already had a masterclass on founding a law firm, at least as of now. The bigger, the better. Those who are thinking of having one man, have many law firms, the doctor has just given us a good guidance, and we are glad to have him tonight. Maybe just before, I think now we should be heading to tax, and my first question is, I'm wondering, within the firm, you said to major in tax, and as a Chivanja lawyer, as my senior said, I'm wondering why tax are not any other law, like land transaction is, any civil litigation whatsoever. Why majorly tax? Thank you.
Alfred, I'll answer that in two aspects. One, the short answer is a bit of coincidence, what some people call luck sometimes, and then the other one is personal conviction. But I'll start with the coincidence part of it. Like I explained, I joined university, and please don't calculate my age. I joined university in 1991. When I joined university in 1991, March, later, around August, September, the Uganda Revenue Authority is formed. That's in 1991. So first coincidence, you go to law school, Uganda Revenue Authority, which was not in existence. In fact, prior to that, what was happening was you had customs and what under the Ministry of Finance. You then have an act of law, of parliament, an act of law, where they now provide for an establishment of an authority called the Uganda Revenue Authority. 1991. Second coincidence, they appoint the head of legal services. That the head of legal services appointed was Professor Bachibinga. He had been working in Nigeria, in the university in Nigeria, and so had been invited as part of the expatriates at that time. URA was started by expatriates from Ghana. The expatriates came from Ghana and started URA. But when it came to legal services, in charge of legal services, Bachibinga is appointed, a Ugandan. In 1992, when I got to second year, and I now have to choose subjects, because at that time, during our time, we were doing Makerere in 3 years. Law was 3 years, a 3-year course, not 4 years. In second year, you would choose subjects. So when I got to second year and I'm going to choose subjects, Bachibinga decides to introduce a subject to start teaching part-time at Makerere and start teaching revenue law and taxation. So another coincidence. I have a subject, revenue law and taxation. Of course, URA was the in thing at that point. Everyone was talking about URA, everyone was talking about taxes. I picked interest. I wanted to know more about this subject called tax. I found out that there is no tax unless it's provided for in a law. So everything tax is law. You can, if you introduce a tax and it is not within a law, it is not enforceable. So my natural conclusion was that if I am a lawyer and tax is law, then I'm the best suited to interpret tax. That was my conclusion. I said it must be a lawyer's domain to be able to interpret the law. At that point in time, taxation was a domain of a preserve of auditors. PwC, by then it was called Coopers and Lybrand's, Ernst & Young, KPMG. Those are the guys who were talking tax. So anyway, I pick interest. I decide to enroll for the subject. Brave decision, I must say. Brave because, remember, you're a student. You want to pass. Your interest is passing. Yes. And you are going to start a subject that has no precedent. No past papers. No past papers. But you want to do it. Why? Because I believed. And as I like to explain, belief is very central to success. Once you believe in something, that is very central to success. In fact, they say your belief becomes your reality. So, I enrolled for the subject. We were only 3 who studied that subject. Who were brave? The brave ones, the risky ones, those who are willing to take the risk. But I believed that the only risk in life is not taking a risk. That's my philosophy. The only risk in life is not taking a risk. Take a risk, as long as you believe in what you're doing. Anyway, so the point is that I then studied tax, complete campus, go to LDC, complete LDC, and like I said, start a tax practice. So like I said, a bit of coincidence, things happening at that point in time, but also the belief that lawyers are the best suited to interpret. And as can be verified now, taxation is the fastest growing sector in our legal profession. It's the fastest growing sector. There are other sectors that are growing, like insolvency, but you now talk of tax lawyers, we now have a tax hub. Edwin, yes, he's in the house. The founder of the tax hub. Lawyers coming together and discussing. So, yes, that partly explains why I venture in tax. But I want to also mention something very important. In my introduction of who I am, I mentioned that I am value-driven. I believe in values. There are some things for me that I wake up, leave my bed at 4 a.m., things that drive me. And those values, for me, are 3. Number 1, my first value is excellence. Once I set my mind to doing something, I want to do it excellently. Not perfectly, because there is a distinction between excellence and perfection. Excellence, strive to do your best, and that is it. So excellence. And that explains why I decide to focus on tax in particular, and not spread my risk, as they normally say. So excellence, because I wanted to do tax and I wanted to do it right. That's number 1. Number 2 is impact. My second value is impact. How am I impacting? 1, myself, but how am I impacting the people I'm dealing with? My staff, my colleagues, the people in the community. And then lastly is growth. Elison mentioned growth of the farm. I am a believer in growth, especially at a personal level. I believe that as a human being, if you are not growing, there is a problem. In fact, many people struggle with growth because growth is closely associated with change. You see, you can have change without growth, but you can never have growth without change. You can have change without growth, but you can never have growth without change. So for you must be willing to accept change, which is something that people struggle with. We all struggle with accepting change. So these 3 values for me informed my focus on tax. How does, for example, if I may answer, someone may be asking, how does growth deal with taxation? As a person, how do you grow when you're doing tax? Taxation is one area of practice where every year there is an amendment. There is a new amendment. There is no year where there is no finance bill that is passed in parliament. So you are always on your toes. There is always something new to learn. There's always something new to learn. Lately, there's been a movement by the URA to focus on what we call transfer pricing. That is something that was not in existence 10 years ago. We have to learn about it. We have to practice. So for me, that fed into my value of growth. Thank you.
Basically, processing tax is purely serendipity and value-driven. Now, when you are talking, there are very many people on call and they are non-lawyers. They're even having their questions in the comment section. I'm sure Joe will come to that later. And they are wondering what exactly makes tax law to be such complex and engaging field from your 30 years of practicing tax.
Tax law, you must be present. And I talk about presence in the real sense of focus. Many times we avoid the details. Taxation, you must pay attention to the details. You must be present. You must be abreast with the developments in the tax area. But there is a misconception. Well, I'm not saying it's misplaced. There is a misconception that taxation has got to do with mathematics. That when you are dealing with the taxation, you must be prepared to do the numbers. And many lawyers shy away from numbers. At least Elison confirms that.
Unless until it is money.
unless he's counting money. But yes, there's a bit of calculation. But that's where I emphasize collaboration. That's where I emphasize collaboration. The accountants, for me, are my partners. They are not my competitors. You know, Steve Jobs used to say that competition is not that I will do it better than you. Competition is that I will do it differently. That's what competition is all about. That I will do something differently. Not that I will do it better than you. I will do it differently. For me, auditors are not my competitors. They are my partners. And why do I mean? When a matter comes to me, and it has got to do with reconciliations, returns, figures, and everything, the auditor will handle that. And why is that important? Because the auditor will become my witness when I eventually go to court. I need a witness. I need someone to explain those figures to the court. And who better than the auditors who have studied? So for me, it's synergy, teamwork, working together. So when we talk about tax being complex, I think for me, yes, it is complex when you want to hold everything. When you want to be everything. But when you work as a team, I can assure you taxation cannot be complex. But secondly, I think it is in first year at Makerere at law school, where they teach introduction to law and they teach the rules of interpretation. Taxation has got cited its own peculiar rules, but they are not far different from the normal rules of interpretation. For example, one of the rules is that if there is ambiguity, if for example, a statute, a provision in the law is likely to have two interpretations, which happens sometimes, then it must be interpreted in favor of the taxpayer. That's a rule that is specific to taxation. But apart from that, these other rules of interpretation apply. And like I said, these are purely provisions in a law. And you are interpreting them based on the rules of interpretation and precedent, decided cases. And so, as far as I'm concerned, the complexity is self-made. Otherwise, taxation is not complex.
For those, I think I just one question from, there are many comments on the comment section. Someone is saying, thank you, he's following, the bigger the better, thank you for that, he's enjoying the conversation. Let me see, Natif has a question regarding the URA case which you commented about, commenting that seeing as there is a regional fight for capital and capital seems to go to markets like Mauritius that have flexibilities in their tax regimes that lessen tax hits on capital gains, what reforms do you reckon can help make Uganda an attractive market for such capital? But yeah, I think you'll get to answer that later on. From your experience advising clients, what are the most tax challenges which Ugandan businesses face? Before you get Natif's question after that. Thank you.
So, what are the most challenges faced by companies and even individuals? Because our tax system, beyond companies, individuals are also liable to pay tax. There are many challenges, and I would spend the day here trying to enumerate some of the challenges. But I'll look at what you call the general challenges. One of them is the lack of consistency. You know, businesses thrive on predictability. When I invest in your country as a foreign investor, for example, I come here and I go to a lawyer, for example, and say, what is your tax regime in Uganda? What am I supposed to have at the back of my mind? I expect to factor that in my business plans. I will know that when I deal in this particular business, either it is exempt or it is subject to tax. If it is to be taxed, then it will be taxed at this rate. That is clear. So I will know if I'm to pay 30% corporation tax and pay 18% VAT on some of my purchases, I will factor all that and know I will make this margin at the end of the day. That is very critical. So, for me, in fact, I would say certainty, if I would use the word. Although there is a saying that the only certain thing is uncertainty. But what people are looking for is certainty. With tax laws. They want to come here and not halfway have the goalposts shifted. So certainty is one of the challenges. Now, is it very prevalent? I think increasingly it's the URA and the Ministry of Finance are doing a good job. They are beginning to ensure that the framework under which these yearly laws are made are within what they call the domestic revenue mobilization strategy. It's a 5-year. They have a 5-year strategy that the government came up with, and in that strategy, you can read their mind and how to progress. So certainty and predictability is one of the challenges that most companies face. Yeah, if in the interest of time, I'll leave it at that.
If you're just joining us, welcome to the Judicial Service Conversations. We are discussing the Taxman, the Constitution, and the limit of URA's power. And we're going into the meat of that conversation. You've just heard that one of the big challenges that businesses face is certainty and predictability. The instability of the tax laws. I don't know if URA guys are listening. Sometimes they get greedy. They wake up, the Ministry of Finance, they wake up, they see a sector is working very well. They say there's a lot of money in mobile money. Tax! People are making money, tax! People are making money, tax! And so this is a bad thing. But now, if you're just joining us, welcome. I'm going to hand over to Joy E. Mbabazi. Oscar Joy is also a young lawyer. She's part of the...
Dealing with young lawyers.
Young
today.
lawyers. We are dealing with young lawyers today. Even me, I'm also a young lawyer. But Joy, on top of being a young lawyer, is very instrumental in communicating with young lawyers. And not just with young lawyers, but really with helping lawyers through many of the challenges that they are going through. And I just want to hand over to Joy. She's also... She works with Alfred in this thing they call the Young Lawyers what? The Dear Young Lawyers series. Now there are 2 people who work there. One of them is the team leader. The other one is the founder. so they know how to balance power or how to share it. But over to you, Joy.
Thank you very much for that. Well, we are balancing the power. We're doing some numbers there. It's good to have you here for all our listeners. This is Judicial Service Conversations, and we're talking about the Taxman, the Constitution, and the limits of URA power. And we are happy to have Dr. Kambona, in case you've just joined us, the man who you cannot miss to mention in any conversation that concerns tax in this country. And so far he's had some tweetable tweets. Before Twitter was rebranded to X, we used to say it's a tweetable tweet. You know, so he's been throwing some of those captions like the only certain thing is uncertainty. And he also said something about the only risk in life is not taking a risk. So several things, you get it? So I hope that among other things that you're getting, you're picking on these things because I believe that they're very impactful. I'm going to be getting into reactions, responses, and questions online. So in case you have a question, please do share it, leave it in the comment section, and I'm going to get to it. But as you prepare and as you get ready to do that, Dr. Kambona, you recently completed a Doctor of Laws in Taxation from Makerere University. And you've mentioned, and Ike has also mentioned that, he does not understand. After all this time, when you are at the peak of your career, somebody would say, what inspired you to pursue a doctorate at this stage of your career? For someone out there, maybe that is doubting and wondering and thinking, maybe after I get my degree or 2 degrees, that is it. What motivated you to go back? Over to you.
The story about PhDs is not a popular story. There's a joke that goes around about a doctor, a PhD holder, who met what we call unlearned friend, and decided to go for a picnic. So they go for a picnic, find some piece of land, and pitch their tent. So at night, they go to bed, sleep. In the middle of the night, this unlearned friend turns and checks the PhD holder and says, "Look up, what can you see?" The PhD holder then says, "I can see the galaxies circulating in their orbits, and the fact that it was hot today, the velocity means that we shall have some rays of the moon." Oh, long story. The unlearned man turns and says, "All right," and calmly says, "Well, the point is that the tent has been stolen." So while this guy was trying to look at these things, the tent was gone anyway. No, but the whole point about my going back to school had to do with my desire for empowerment. My desire for empowerment. I mentioned knowledge is one of the things I look up to, and it is through knowledge that you are empowered to serve. It is through knowledge that you will find solutions. And if I am to find solutions, you have to go back and learn. Education, by the way, some people have defined education, not that education is not the learning of facts, but education is training the mind to think. Education is not the learning of facts, but training the brain, the mind to think. You need to think. We need to learn to think. Some people normally say, think outside the box. So for me, thinking is very important. In the introduction, Elison said Oscar had it all. He doesn't know who was teaching. No, there was a lot for Oscar to learn. There was a lot for Oscar to learn at Makerere. Why? Because, and that's why my topic was an interesting area. It was a topic that was not dealing with issues to do with assessment. It was dealing with enforcement and the rights of people, the rights of taxpayers. That balance. You want taxes, but I have my rights. How do we balance? So, without going into the detail, the point was, am I learning? Am I training am I broadening my thinking? In fact, I am a person who believes that there is power in knowing what you don't know. There is power in knowing what you don't know. Today, having graduated from Makerere, I am a different person. There are things I have learned along the way. There are things my supervisors have guided me in the course that have made me different. So, empowerment. Now, you may ask, what's this whole thing about empowerment? I am thinking in terms of this. First of all, if I may digress a bit, human beings have got 3 endowments. We are born with 4 endowments. Number 1.
I'm a bit scared.
The first endowment we are born with is self-awareness. Nobody knows you better than yourself. You know yourself. You know what works, you know what doesn't work. You know, what you don't know. In yourself. You may hang out and say, I know everything, but in your heart, in your soul, you know you don't know. You actually observe your thoughts. So the first one is self-awareness. The second one is imagination. We are born with imagination. We can imagine things. You can be here today and imagine things in 2075. That's why we talk about a vision. We talk about Vision 2040. Imagining a Uganda in 2040. That is exercising imagination. Number 3, one of the things we are born with is conscience. We know what is right and what is wrong. In you, you know it. That this is right and this is wrong. I'm doing this is right, but it's wrong. And that we are born with. But finally, and that's where the interest comes, why I go back to school. We are born with what we call free will, choice. We are born with the power to choose. And the only way you can empower yourself is to empower yourself through knowledge, ability to choose. You cannot choose between A and B unless you know B exists. So you must first know that B exists before you choose it. And through learning, you can empower choice. And I am happy to say that learning, continuous learning, empowers choice. So, why go to school at an old age, sleep at 2 and wake up at 3, 1 hour sleep? It's because of empowerment. In fact, my daughter was very annoyed when she learned that she still had to go and see a doctor despite me being a doctor. For her, once daddy was a doctor, then I didn't have to go to and wait in the line for a medical doctor to treat me. But yes, those disappointments will be there. But yes, empowerment was the key driver. Thank you.
My friend Nicholas Opio likes disturbing honorary doctors, but now at least you can tell him that today, Nicholas, we have a LLD in the house.
Absolutely. That was such an amazing answer. And I hope that if you are at some point in your life where you think you have arrived, at least there should be some question marks there. And I like what he said, that he went back out of the desire for empowerment, and it's through knowledge that you are empowered to serve. Through knowledge, you are able to find solutions. And there's something important that he talked about education, that it is not the learning of facts, to the contrary, unlike popular belief, but it is the training of the mind to think. And he says it is very, very important to think. You share with us very, very insightful pointers to take there. And so on to the public to see what it is that they are saying. There's quite a lot of response here, and we want to appreciate you for hanging out with us, for listening. There's a question that came in earlier from Council Aloyo. He says, to what extent do the enforcement powers granted to the URA under the Tax Procedures Code Act and the Income Tax Act, e.g. distress of property, risk violating Article 26 of the Constitution, which protects against deprivation of property without prompt, adequate compensation? I don't know if you'd like me to repeat that.
Thank you. And thank you for the question. You said it was? Aloyo. That's the more or less the crux of my thesis. And I'll give some bit of context so that we are all on the same page. Taxation in Uganda is either voluntary or involuntary. You do a business, you get your accountant, you get your lawyer, you do your calculations, you make a return, what we call a tax return, you generate a payment advice, pay your tax, deal, concluded. URA has no problem with you, you move on. But there's another side, the stubborn one.
That first one is most of our listeners.
Yes, the lawyers today are the voluntary ones. They pay their tax and move on, no problems. But there's what we call the involuntary side. You make your return and omit certain income. You make your return and make more deductions from the income, so therefore reducing your tax. You actually don't register for tax at all. You disappear. Those
farmers.
Maybe. It's the second category that needs what they call the stick approach, the carrot and stick approach. Now, to be able to enforce against the involuntary category, URA is given certain powers. One of the powers, the one who posed the question, a lawyer posed, is that one of the powers is distress. Come on your property, attach property, go and sell and recover taxes. But they also have other powers. One of the powers is to close your business. Put a seal and close your business. One of the other powers, interesting, is if you are challenging me, pay 30% and then go to court. Now, the question, and there are other powers, of course, what we call, there is a power of agency notices. Agency notices, if I could explain, is where you are having a problem with URA and you have not paid your taxes and they have demanded for your taxes. They can issue a notice, what is called an agency notice, to your bank to say collect immediately this amount of money and remit it to the URA. That can be done even without going to court. Now, these enforcement powers are aimed at helping URA. The problem is, as the question is, do they violate articles of the Constitution, in particular Article 26 and 27 of the Constitution, the right property and right privacy. So these sections say I have a right to enjoy my property. Of course, there's exceptions, and that is what the limitation clause. That's Article 43. There's a limitation which says, yes, those rights can be limited in certain circumstances. And that's why the Charles Onyango Bo case with Andrew Mwenda versus Uganda talks about the limitations to certain rights that you own. So the fact is that, yes, you have certain rights, but some rights are not absolute. There are some absolute rights, fair hearing and torture, yeah, those are absolute. But Articles 26 and 27 are not absolute. They can be restricted.
Privacy
and property. They fall under that restriction clause, Article 43. So, that said, the restriction has got its own boundaries. You can restrict because of public policy or public interest. The question is, are those restrictions within the public interest? Now, what I found, in fact, my key finding was that in the course of implementation, there has been an infringement of these rights. The infringement is in the implementation, the enforcement side of it. And I don't want to go into the details, but there are quite a number of instances. And this is not to apportion blame. because when we are talking about certain things, we must differentiate between critiquing and criticizing. You see, I am not criticizing, I am critiquing, and that's what I did in my thesis. So when I'm not critiquing the current people who are office bearers in URA, no, these ones are doing a good job. I am critiquing the system that they inherited. In fact, many of the cases we are dealing with are predating the current administration. But I'll give an example. Let's deal with something that is obvious. The issue of 30%. Yes. You come to me. I have given you my workings. I tell you my calculations show I am supposed to pay 100 million. You tell me no. You have calculated wrongly. For us, it is 1 billion.
10 billion.
Or 10 billion. Now, I say, okay, that's your position. Fair. I also have my position. Let's go to an arbiter, an independent arbiter. Let's go to the tribunal. Let them hear our side, let them hear your side, and let them decide who is right and who is wrong. But then the law says, no, wait a minute. First give me 300 million shillings. Before you go to court, whether you are right or wrong, just give me the 300 million. Then we can argue. Now, of course, we know as lawyers that there are things in your control and there are things out of your control. I like to emphasize that please focus on things in your control. Try as much as possible not to focus on things out of your control, otherwise you will get pressure.
Leave the Iran war alone.
Leave the Iran war alone, let it happen, let the Americans do what they are doing and whatever. You focus on the things in your control. But there are things out of your control, and one of them is time. How long the dispute is going to be resolved. I don't want to mention, I have a case. You can come for details. But it's in public domain. I shouldn't hide it. I have a case of NSSF versus URA. I received instructions in 2013. The case is in the Court of Appeal. The point I'm making is that it is out of your control. I have paid 30%. The dispute is ongoing. My 300 million is locked up. My working capital is locked up. Workers' savings are no. This case they refunded. They refunded whatever. So I don't want to be unfair on this point. Yeah, but they refunded once the matter was resolved at a lower court. No, but the point I'm making is that it's unfair.
2013 up to now.
It's unfair where you are telling one party to pay 30%. Now, is this a new something? Is that something new I'm coming up? In my thesis, I did a comparative study. In my mind, I was saying, well, maybe things are done different in other countries. I found, and I did a comparative study of Kenya and South Africa. I found that this whole point about 30% actually originated from South Africa. They have what they call pay now, argue later. For them, their principle, pay now, argue later. But there are some restrictions. That the court must have a limit time within which to argue the case. So I will pay you, but if the case is resolved in 3 months, I will know whether the 30% is payable back to me or whether I pay the 70%. So while we borrowed some of these provisions, and it happens, I don't want to go into detail, in other provisions, while we borrow some of these, we do not do so mindful of the reality on the ground. And that is where the challenge comes. You don't, so you have this problem. So anyway, the long and short is that yes, there are certain provisions that are actually violate and infringe the rights of taxpayers. You close a business, which is not very common, but you close a business, the law says close in, you must close it for not more than 15 days. What happens? You have some businesses, there is a case I cited in my thesis of One Solutions versus URA, where the case, it was 2013, and that's why I say some of these cases predate the current administration. It is 2013, where the company was closed for 5 months. And you can imagine what impact that can have. You can imagine what impact that can have on a business. For you to have your business closed, even imagine a law firm closed for 5 months. You will come back and all your clients have been taken by elison. Yeah, so yes, that's he's right. Yes, the enforcement side of it is definitely a point of concern.
Thank you for that. I believe you've ably responded. There's been a couple of people that were also bringing up the Article 26, and I want to think that has been sufficient. We're going to take one more question. I see there's several of you. If time does allow, we'll come back, but I'll just recognize you, DK, Stephen, Seguya, Enoch, Idris Chigundu. There's always somebody who calls himself Bomboklat. But he's also now added Gumite. Okay. We see you. I don't know who you are, but yeah, so you're Gumite and that. Dennis Kabila, we also see you. Kagame Dixon, Patty Nsimbi, Jesse, Gen Z for Gen 7. Okay. Philip Morani. And everyone that is really listening and that has gone ahead to just comment or leave a question, we want to say that we see you and appreciate you. Now, there's a question that came in from Anthony Natif, which says that his arises from your conversation on the URA Talo case. He says that seeing as there is regional fight for capital, and capital seems to go to markets like Mauritius that have flexibilities in their tax regimes that lessen tax hits on capital gains, what reforms do you reckon can help make Uganda an attractive market for such capital? Over to you.
As the country develops, one of the key ingredients or aspects is capital, finance. You either raise your own money, but of course you need money from abroad. And normally that comes in ways of investment, foreign investors. It can also come in terms of grants and aid. But the last two, grants and aid, are becoming scarce lately. So you need foreign investors. The question is, what do we need to do to encourage that? My answer, in no uncertain terms, is ease of doing business. The Mauritius, the example he gives, is ranked among I think the top 3 in Africa in the ease of doing business. People want things to move. Now, one of the things they have done right in Mauritius is predictability. The other thing they have done right in Mauritius is in terms of policy changes. So how do we encourage people to come in? Can we streamline things? Can we make it easier to do business? Of course, we are doing so many things as a country in the right, in terms of exchange, foreign trade, international trade. I mean, we allow capital in and out. You are free to bring in your money. You are free to take out your money. So, but in terms of taxation, I am saying make your system easy to deal with, clear, certain, and let the processes comply with the law. The moment you comply as a country with the law, people will come The moment you respect, for example, contracts, and that's why for me, the Talo case, the case he refers to was very important. Talo was saying, you told me, you promised me, I came to you and you said, I won't tax you. What has changed? And that's why it was important that this matter was resolved. Because the other investors were watching. People were asking, yes, I mean, if you cannot respect your own contract, then what happens? Sanctity of contracts alone is very important. So yes, it's those things. But finally, again, speaking of enforcement, we have done a good job as a country on policy, filling the policy gaps. You know, you've got a new section in the Income Tax Act on petroleum. You've got all these provisions on transfer pricing rules being put in place. You've done all these changes. You've introduced IFRIS. You've done, the lawyers now are complying. Fine. But there is a problem called the compliance gap. The compliance gap. Compliance gap is about morale to pay tax. What the morale of the taxpayer, the willingness, you will not make advancements in tax collection unless there is that voluntariness. If 80% of your taxpayers have got to be audited before they pay tax, then you have a problem. Then you have a problem. I can assure you, then you have a problem. Our tax to GDP, the amount we collect as revenue compared to our GDP, the ratio is about 14%, 14.3%. South Africa, which is in, I don't want to talk about Denmark, which is in the 40% and the rest. South Africa is collecting about 28% of our GDP, of their GDP. That means for every 100 shillings in an economy, 30% of that goes to the government. That's a big amount. For us, every 100, 14, because our ratio, tax to GDP is 14. So 14. The sub-Saharan average is about 20 to 22%. That means we still have a long way to go. And I think the president has been mentioning that over and over again. Why is it that we are still hovering around 10 to 14%? It's because we need to address the compliance side. The voluntariness of compliance. And I will state the last point on this one. Taxation's foundation, the whole foundation of taxation, is based on what we call the social contract theory. The social contract theory, and that's one of the theories I relied on in my thesis. The social contract theory is purely that people came together, they decided to forego certain rights to a selected elected people called the government. They agreed to finance those people by paying taxes. Out of their income, you contribute to the running of that government. But there was a part of the agreement, part of the bargain is that you would provide us services. The money was going to be used to pay for services. So this social contract theory fits in what I call tax morale and fits in tax compliance. If you fix that side, compliance will also go high. So compliance is a very important point. And to your question, Mauritius is doing well on that front.
Okay, if you're just joining us, we are talking all things tax, the Taxman, the Constitution, and the limits of power. Where we are learning about the social contract. We are learning about distress. We are learning about Mauritius. We are here learning today the Parliament of the Bible in special session. Before I come to Martin, a number of questions which I'm seeing, and maybe I will just take us through some of them that have been highlighted. First of all, there was one from Bombocrat. Somebody asked me about Mr. Bombocrat. If you go are you allowing to read that man's question? That's not a good name. I don't know what's wrong with his name. But his question was answered, but maybe I'll read the question because Philip Morani answered it. That's an interesting question. It's an interesting question. He said that he imported a used phone. I don't know how he knows it was used or where he was using it from, but anyway, he imported a used phone worth 3 million shillings at the time. When I went to DHL to pick the phone, URA charged me 50% tax on the price of a brand new phone, and the price of a brand new phone was 5 million shillings. So I paid 2.5 million shillings in tax for the phone. Did URA scam me? Now, Philip has said, no, they didn't scam you. 25% was import duty, 18% was VAT, 6% was withholding tax, 1.5% was infrastructure levy, and where there should be a threshold on importation for personal use. so there's a discussion there, but there's a question. There's a question coming from Edris Chigundu. Edris Chigundu, I think, is the editor of Beg Media, and he wants to know how you can break down our tax policy to a Ugandan business person in Chikubo who is semi-illiterate. How do we simplify the tax education of such people? And then there's one other question that's coming from Joshua Biamazima, who is asking, the draft tax policy measures propose eliminating legal cost awards in tax litigation and denying costs where taxpayers introduce evidence at the tribunal stage that could have been submitted earlier to URA. While URA argues this will encourage procedural fairness and protect the consolidated fund, could this reform risk undermining access to justice for taxpayers who rely on cost recovery to challenge incorrect assessments? So now just to explain that briefly to those who are listening, there's a draft tax policy measure that is saying taxpayers should not be given costs if they go to the tribunal and win, but they bring evidence that they should have submitted earlier to URA. If you do not give URA the evidence earlier, you should be denied your costs. So, and he's asking whether this proposal is undermines access to justice for taxpayers. Yeah.
Is that basically the right now to incriminate yourself?
No, it's not. The question is that you have a right. You are given an assessment. You challenge the assessment in the tribunal. When you go to the tribunal, you win. You are found to be correct. But the evidence you have brought to the tribunal, you did not give it to URA at the time of assessment. And so they are trying to that if you do that, you shouldn't earn costs after winning. You should get from the wins you have gotten, you should pay the lawyer as opposed to the costs following the event. Now, for those who are listening, costs follow the event. That means that if you go to court and your URA and you lose because you have given me a wrong assessment, the person who you have taken to court and he has defeated you in court, the event of his victory means that the costs he has incurred because of your inability to understand the tax law, you should pay him back his costs. So we call that costs following the event. But so over to you, Oscar, whether this issue, because I think the issue is raising is a lawyer issue of lawyers are now going to start being denied our costs. Yet they could give us those costs and even take some tax on them.
I think Elson has answered the question. I think we are in this room. We are all conflicted. We are all conflicted because certainly we. I mean, if I would start with the last question, this issue of costs is a very, 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 very important aspect that we need to address. And I think the Law Council will definitely have a position on this point. But of course, it's still under discussion, and we hope that the genesis of such a provision would be analyzed and understood. My view is that we need to contextualize this issue of producing evidence at the trial. There are certain exceptional circumstances where you come across information that clearly explains the issue. What do? Do you hide it? You apply to the court, and it's the discretion. Those are discretionary powers of court to decide whether that evidence should be admitted. If the court admits that evidence and I win, and then you say don't pay me costs, then you're penalizing me for doing the right thing. I can understand the intention behind it. The intention is to cut out people who hide information and wait to produce it at the hearing. And URA is saying, if you brought it to us earlier, we
would have found a way around it.
We would have maybe found a way around it, but we would have resolved this issue at that point.
Yes.
Fair enough. I think there is a point. I think we must be open in that respect. If I have information that I know really helps to resolve this issue, I should not first go to court. I think that's it. The problem is that the processes itself. The Tax Appeals Tribunal law is very interesting. And I think even the Income Tax Act, the burden of proof is on the taxpayer. What burden? To prove that the assessment is wrong. You who made the assessment, you keep quiet. And then me, the burden is on me to prove that whatever is wrong. Yes, I can understand, but why don't you first prove that you are right? Why don't you first prove that your assessment is right? So these are issues that we need to debate. So it's a matter that we will definitely have to look at and get opinions and do a benchmark. What happens in other jurisdictions? What happens in other jurisdictions? And maybe we'll come up to an amicable position. Lastly, there's a question on tax education and awareness. That Chikubo businessman, what happens? Is he aware? Is he educated? I must give credit to URA. The current URA, I must give them credit. I know people have had their issues with them, but they have done a good job on education. They've tried anyway. And for me, awareness is very critical, because I am a believer that awareness encourages compliance. If I am aware of my obligation, if I'm aware of the time, for example, when I'm supposed to pay my tax, if I'm aware of where I'm supposed to pay tax and how much, that improves my compliance. I've been reading in the media, there is a pull-out, I think every Thursday or Tuesday, ask the Commissioner General. And I've been reading some of those questions that people have been asking, and URA has been doing a good job in asking. So yes, is there room for improvement? Yes, there could be room for improvement. For example, and this is a bit controversial, I have attended in the past. I attended some seminars organized in taxation, and people, the first question, why am I paying taxes when the roads have not been constructed? Why am I paying taxes before the hospitals are stocked? Those are questions that people have. In certain forums in the past, what has always been the default answer? Well, for us, our role is to collect. And which is right. The role of how the money is distributed is Parliament, Minister of Finance, which tax to implement and how. Yes, that's a fair one, but there is need for sensitization on the broader position, because taxation, by the way, is defined in certain circles as the price you pay to live in a civilized society. There must be a price that me and you have to pay to live in this civilized society. So the awareness, I'm saying there is room for improvement. We need to encourage them, but we, even at our individual level, as lawyers, as business people, whatever, we need to also educate ourselves about tax. But you can always consult KAA, Oscar But thank you very much.
Allow me to, if you're just joining us, welcome to Judicial Service Conversations. There are still so many questions. I think I'm seeing over 30 questions that have so far been asked. Right now, I'm seeing, yes, and we shall have one in the room. There are so many. I am seeing people talking about the principles of legality. But before I go to the questions in the room, and maybe you'll handle some of the questions in the room. And maybe you'll handle some of the questions in the room. Forgive me, our YouTube audience will forgive me. I think there was something wrong with the microphone, but I think you'll handle some of the questions in the room. But I think the next person is someone you know very well, Mercy Makabai Chemutai, a very senior lawyer at KAA. Mercy is also one of the hosts of the Judicial Service Conversations. She's also one of the young lawyers.
Yes.
Yeah, although she has served with us for some time, she graduated extremely young, so she's now just young. So she's one of the young lawyers, but also she's been a fundamental part of the Judicial Service Conversations, and I think Mercy has some questions to throw away. But as Mercy is getting herself ready, if you're just joining us, we are firing questions about taxation. We are understanding tax. If they taxed you for your phone or for your shoe or for something else, we are being told that it is the price you pay to live in a civilized society. So pay your taxes, and if you have a problem, go and see a lawyer. And if you have a big problem, go and see a good lawyer. And also we have been told that taxation is the social contract. It is the all of us come together to fund the people to rule us. And this social contract is something you have to live with. I think as someone who once said, I don't remember who, that the two things that you're sure of are death and taxes. But there's one other thing you can be sure of. A very good question from Mercy Makabai Chemutai.
Doctor, it's indeed an honor to sit next to you and have an opportunity to ask you these questions. On my behalf, but also on the behalf of a number of people who are behind us, very interested in this conversation. I had the benefit of attending your defense, and I saw a question here that I know you're very passionate about. So before I even get into my questions, I would like to ask that question. It's from Mr. Kabila Dennis. He asks, Dr. Kambona, in your doctoral thesis, you advocate for the establishment of an independent tax ombudsman. To protect taxpayers' rights. Could you clarify what specifically this new body can achieve that the existing tax appeals tribunal cannot?
Dennis, tax ombudsman is basically a government official, independent government official, who investigates procedural issues regarding taxes and recommends solutions. In other words, you have got a person who is independent and is overseeing what is happening in the URA, and comes up and says, you know what, you are supposed to write that letter within 3 days. It is now 2 weeks and the letter is not out. Tell us why. Can you find a solution? In other words, streamline. And it's cited similar to ombudsmans that we know, like the IGG. The IGG is an ombudsman of government. But here, we are recommending, in my thesis, an ombudsman for the URA. Now, this ombudsman we are recommending an ombudsman because, of issues of time, of issues of speed and cost. So the faster you get a solution, the better. Now, one would ask, why don't you recommend somebody going to the tribunal? Because there is an institution called the tribunal. Why are you talking about an ombudsman? An ombudsman would cut out the processes. For you to go to the tribunal, you must have a decision. There are certain instances that we know today where URA has taken a decision, but it is not in writing. Actually, in the past, one of the clear examples was, for example, deactivating your TIN, your tax identification number. You have problems and your tax identification number is deactivated. Yes, it is affecting you. You can't import, for example, if you're an importer without a TIN. You can't pay taxes if you're a taxpayer and you want to pay your tax obligations. It's deactivated. It's impacting you, but there's no decision. And at some point it was emphasized, if you're going to the tribunal, you must have a decision. So what do? In those cases, the ombudsman comes in and finds a solution. Although I must also credit in this discussion, I must credit the Tax Appeals Tribunal. We have a new team in the tribunal. Young.
We hosted them here.
You hosted them here. Yes, they are absolutely turning the tables. Some of those, I have seen a decision where they have entertained a matter where there is no actual taxation decision. Where there was an infringement, alleged infringement, and the taxpayer went to the tribunal. It's there. So I want to commend them. I want to urge them to continue. But yeah, although some lawyers will say some decisions are ruled in, but for me the question is not whether they rule against you or not. The question is, do you have a decision? If you are not happy, appeal. What's the problem? If you're not happy, appeal. That's why the appeal process is there. So for me, I want to commend them. So the point, going back to the question, yes, the whole notion of an ombudsman actually is borrowed from many countries. Australia has an ombudsman. South Africa has an ombudsman. Kenya is introducing. Tanzania has introduced an ombudsman. Nigeria recently introduced an ombudsman. So it's something that is happening, and it's something that we recommend for the country.
Thank you very much, Dr. Oscar, for that elaborate response. I just want to move to this issue of the social contract. At the beginning of the conversation, you mentioned that you were there right before URA was created. And 30 years down the road, you've had 30 years experience working closely with URA, but also with the other stakeholders in this space. In your experience, what do you think has evolved in the relationship between the tax collector and the taxpayers? And when you look at the next 30 years in this country, what do you think should improve, just in a couple of recommendations, should improve in that relationship? Because I know it ultimately contributes to a better relationship in terms of the social contract principle.
I'll start with the last point, and I think it's an interesting observation. What do we need? What do I think should be done in the next 30 years? Observe rights of taxpayers. That's the finding of my research. You see, the reason I went back to do some of these studies, do further studies, is to generate knowledge. Generate knowledge and share that knowledge. And I think this is one of the things I'm doing today. Yes. The URA and government in general needs to actively consider respecting, promoting, and fulfilling taxpayer rights. Are they not doing it? Not enough, according to my findings. Can it improve things? Certainly. How do I come to that conclusion? Data. I told you when I was doing my research, I did a comparative study. These countries that we are talking about where tax to GDP ratio is 40% are countries that promote those taxpayer rights. And when we talk about these taxpayer rights, it may seem like something far apart. I'll give an example. Article 26 talks about privacy. 27 talks about privacy. One time, I think it was in the last administration, one time the URA issued a notice to all banks and said, give us all information about taxpayers. There was that power that the commissioner can ask for information. Of course, the matter went to court. The banks went to the courts, and the matter and that decision was found to be unconstitutional. Privacy today, business information, is very critical in this day and age. You come and take my business secrets, it can be the difference between my survival and closure. The information I have, the secrets of the idea behind my business, I have developed it for years. Somebody, it can be an individual who is looking for that information, can use those methods to pick that information, and it will work against me. It's those things. Right to privacy is very critical. In fact, in South Africa, one of the cases I followed very critically during my research was a case involving Jacob Zuma, the former president.
We hosted his lawyer here.
You hosted the lawyer?
In that case, Moses Kahane.
Okay. Somebody, an organization in South Africa, decides to apply to South African Revenue Services and says, we want records about Jacob Zuma. We want to know whether he has been paying taxes. We want to know whether he has complied with the tax laws. Fair to that system, they said no. That goes against the right to privacy. He is entitled to keep his information. It's not public. They went to court and the court ruled in favor of Jacob Zuma. But it goes to show how important some of these rights are. And that's the emphasis I'm saying. So 30 years, if you were to ask me, 30 years from now, read my recommendations. Follow the rights. Compliance will go up. I started with the last. The first was?
The first question really is just your observation of how the relationship between the tax collector URA and the taxpayers has evolved over the last
years. Yes. I think the relationship between the taxpayer and the tax collector has evolved in a positive way. There has been progress. There has actually been progress. Of course, we still have strikes. You heard of the traders' strikes. Some people still believe that some things need to be done differently. So there's still some resistance. But on a scale of 1 to 10, I think the relationship is now at 7 or 6 to 7, and it's improving. And you mentioned that after my 30 years experience working with URA, my experience actually included at some point working for URA. There was a time the Commissioner General at that time, Anna-Britt Asland, a Swedish expatriate, decided that Oscar should now be the URA lawyer on some cases. And we were able to put up a Chinese wall between my cases I'm handling for URA and the cases handled for the taxpayer. But these were very few cases, and one of the most notable cases was the Rubble Enterprises case, where we at that point, my argument was that we should go to the tribunal first before we go to any other court. And some lawyers were telling me, but we don't want to go to the tribunal first because of 30%. We want to go straight to the High Court. And my point was, yes, but let's do the right thing. Let's fight one war first. Let's fight the war of, yes, let's do things in a straight way, go to the tribunal, then go to the court. And of course, the Supreme Court ruled that we should actually start in the tribunal. So in that respect, we made some law, you would call it. But the point I'm trying to say is that during that time, having an inside look on the workings of how URA, because I used to attend some meetings as I was preparing for some of the cases I was handling, I could see clearly that there was that friction. But that relationship the gap has narrowed. Taxpayers increasingly, not all, but increasingly are now having a good relationship with the URA. Exactly, yes. It's a good point. We have built capacity.
Yeah. Emphasize something, which is that there is no tax that originates where there is no law. All taxes originate from the laws. Do you think that the different stakeholders, especially the business community and tax practitioners like yourself, are involved in the policy and lawmaking process as much as they should be? And do you think that if more people are involved in that process, it would inform the reception of these laws by the business community? A number of the people in the business community receive things like IFRIS at the end. These laws are changing every year, as you've already highlighted. Do you think that there is need for more involvement in that process?
The answer is yes. The short answer is yes. The long answer is that when you look at my thesis, one of my recommendations is increased public participation in the process, the legislative process. You know, I mean, Law Society will confirm this. There are instances where they have written to us as the Law Society, can we have your comments on the finance bill? The letter is delivered on Friday, the meeting is on Monday morning at 9.
On Friday.
On Friday in the afternoon. Yeah, I mean, clearly the input, if it is there, will not be exhaustive. And for me, for you to be able to appreciate the value of public participation in the compliance process, you need to go back to countries like Kenya. In fact, Kenya, the Constitutional Court is very busy because public participation. If you do not prove that you have done complete public participation, the law is struck down. And they have actually, the court has struck down very many laws on lack of public participation. So public participation is very important. Why is it important? Buy-in. If I am part of the process, if you give me a chance, I'm not saying my views as Oscar or the views of Law Society must prevail. No, it may not prevail. But if I am consulted and I am part of the process and I see that clearly the consensus is against me, the chances are I will comply willingly. But if I feel like the system is far detached from me and I am only called in as when it comes to you want to consult me on when am I sending the check rather than how much I should pay, then there is a problem. So yes, public participation is very important, and it's one of the things I recommend. Enhanced public participation. I'll give an example, just in the interest of time. I'll just mention one area of interest. This whole issue about 30% has been a thorny issue over the years. Uganda Manufacturers Association has complained, all this now, that provision of 30% was in the laws, in the Income Tax Act and the VAT law, and in the Tax Appeals Tribunal Act. So it was in 3 places. But because of the views from the public, investors, business entities, lawyers, they decide now to amend and delete it in the VAT law and in the income tax, but it is left in the income tax, in the tax tribunal law. So you have got all these views received, and the answer is very clear why they were deleting it. It affects access to justice, etc., etc. But it is still in the tribunal law. So the point is that if you agree that something needs to be amended, then do it through. And so these are some of the things that we would recommend as lawyers, and yeah, emphasize the point that I'm making, that public participation is very critical. Thank you.
If you're just joining us, welcome to the Judicial Service Conversations. We are soon coming to the end of this conversation. There are hundreds of questions, but in the spirit of public participation, I will, because we've been talking about public participation, I will really cite two of them. Godwin is asking, and I don't know, some of these questions may be, Godwin, I'm sorry, some of these questions may be billable, but he seems to be asking a question of serious concern that is almost emergency and urgent. He wants to know, what are the restrictions on entering a taxpayer's premises? Now, from the tone of the question, I can tell my brother that he's in trouble. They may enter, but Oscar, maybe you can tell us briefly, what are the restrictions, if any, on entering a taxpayer's premises?
Yeah, the short answer, I'll start with the short answer. I always like, so you can choose whether to continue, whether it continues makes sense, but the short answer is that there's no restriction in our law. URA is entitled to access premises. In other jurisdictions, you must do so with a court order. You must do so with a court order, especially in Kenya and in South Africa, the countries that I reviewed. Here, they will come. In fact, the issue was, can you come to my premises, for example, at midnight? I'm asleep, having my pillow talk.
Emphasis used.
Emphasis added. And you say, please, can we have the records? The records, can we have your laptop? Can we have your phone? And it is, yeah, I think it's a point of concern. And I hear, you say Collins? Godwin. I hear Godwin's concern. And that's the point we are making. Yes, if you have the law that says I can investigate any non-compliance, you have the information that Oscar or Elison or Masse is not compliant from your intelligence. You have the information, and you want to go and look at Elison's computer. Go to a judge or a magistrate, present the evidence, make your case, get a warrant, come and enforce it. I have no problem with that. What I have a problem is that you, the complainant, you're becoming the judge. You want to become the warrant, you want to become the magistrate, and decide at midnight to come to my premises. Because the law says anytime. Anytime. So yes, the checks and balances goes back to the point I made. The correlation between compliance, tax collection, the methods, the enforcement powers, and the rights, and how that informs compliance.
Okay. Some of rapid fire questions. I'll ask maybe 2 or 3 at a go. I think we've done the one of Godwin on the restrictions. There is someone, Enoch is asking, where should the line be drawn between legitimate tax planning and tax avoidance? Where should the line be drawn between legitimate tax planning and tax avoidance? There is also a question here. maybe let me give you that one quickly. So I'm going to just ask you about 4 or 5, so maybe rapid fire questions.
Tax planning is part of tax avoidance sometimes. And that is, you know, there's a difference between tax evasion and tax avoidance. I plan my books and I pay lesser than I should actually pay. That's not evasion. Evasion, I don't declare the income. I made money, I got money from rent, received the whatever, the VAT, everything, and decided to keep quiet and didn't declare it. That is evasion. So that is that's the short brief answer. Yes, and he's asking what is the line. What is the line? The line is very thin when it comes to avoidance and evasion, because clearly sometimes tax avoidance may be construed as tax evasion, although the two are different.
We also have a question from sorry, just if you could hold on. We have a number of questions if you're just joining us. Welcome to the Judicial Service Conversations. We have got a number of questions still coming through. We have a number of questions coming through. Someone is asking, isn't closing a business before a tax appeals tribunal ruling effectively a punishment before a verdict? And then I think many of these, so let me give you two. One is closing a business before the decision of the tax appeals tribunal a punishment before a verdict? Then there is one here which is Adrian, who is asking that every street in Uganda has a Chinese. What informs the conclusion of double tax agreements with certain countries and not others, which we seem to be trading with almost on a daily basis? So I think he's saying we have, maybe Adrian will correct me, he's saying we have very many Chinese businesses here, but we may have double tax agreements with the people who are non-Chinese. I don't know if that's what he's saying, or if he's complaining about the presence of Chinese. Bomboclat is still arguing about his phone. I think he says that they Googled the price of the phone and Google results showed them 5 million. He pulled up receipts and even directed them to where they can buy a phone at that price for. And of course someone is informing him that the explanation he was given was basically he was being explained to how he was legitimately robbed. But I think maybe I'll stop there. Over to you, Oscar. Quick fire questions. We just have a few minutes left, and I'll have one question from the audience in the spirit of public participation.
Closing business as a punishment, well, the law provides for it, so it's not a punishment. It's a method of enforcement. But one of the things I wanted to mention was that in South Africa and Kenya, the two countries I studied, they actually removed that power from the revenue body. And the argument was, you do not want to close the business that is going to raise the money to pay your taxes. You want me to pay 100 million, but you've closed my business where I would have generated the money to pay 100 million. So it's a chicken and egg situation. What comes first? Should we close before you pay, or should we close so that you can pay? Now I think for me the point here is that yes, it's a power that is granted under the law. As lawyers, once the power is granted, then it's not illegal and it's not a punishment. But in terms of enforcement, remember earlier on I mentioned a case that I considered and reviewed in my thesis. This was a case involving a company called Wana Solutions. The URA had found that there were some taxes not paid. They go and get this company and demand taxes from the company. The company was supplying gas cylinders. So in the course of that, they then seal the premises. So the company then, there were back and forth discussions, but ultimately the matter ended in court. It was after the court decision, after 5 months, that the premises were opened. Now, so those yes, you may have the power, but remember the impact it will have. Yeah. Now, the second question is about the Chinese and the double taxation agreements. You see, I mean, just to give some context, double taxation agreements are agreements where you enter an agreement with a foreign country and you agree that the country that is doing business with you, for example, a country like Kenya or South Africa, the companies that will invest in you will either be taxed in one jurisdiction or not in both jurisdictions. Now, I don't know how that then increases Chinese on the streets. As you pointed out, the question was not as clear as it should be. But double taxation agreements are encouraged. We encourage, in the tax space, it's encouraged to have double taxation agreements because they encourage cross-border investment. You see, if I'm going to be taxed in Uganda and then be taxed again in South Africa, then why don't I just invest in South Africa, where I will be taxed once? So it's important to have these double taxation agreements, and they encourage cross-border investment.
I've just seen here that the question is supposed to be anonymous. Just for our YouTube audience, I think our microphone had gotten off. We had from Mr. Julius Caesar Rugaya, which was supposed to be confidential. We were not supposed to say his name. And I think he has friends in URA, but he wanted to ask tough questions. But anyway, just for correction, this question is not from Julius Caesar Rugaya. Anybody who thinks it is, please take note. He says the person who is not Julius Caesar says that URA has made it a habit to use, this is certainly not Julius Caesar, to use the fallback method of customs valuation while dealing with imports such as vehicles. So I think he's using nice words for Mr. Bomboclat's problem. This is in spite of court decisions, including one from the Court of Appeal, with respect to the constitutionality of the method. Courts have emphasized that URA must follow the sequence of methods in the East African Customs Management Act, starting with the valuation method. While taxpayers are failing on compliance with paying taxes, URA is failing on compliance with the law and court decisions. What remedies are there for someone, let's say he's called Bomboclat, he says, whose imports have been subjected to a wrong valuation method? Can URA give the guy back his 3 million shillings? It was 2.5, just so that we don't cheat the taxman.
That's a question for Bomboclat.
It is yes, it is more for
not Julius Caesar.
Not Julius Caesar.
I think well, that's customs area, an area of practice. The issue about the method to use has been, as rightly put in that question, been a subject of judicial interpretation, and the courts have been clear. If I come to you and I'm giving you the value I used, you must prove to me why you're not going to take it, so that you can then go to the next stage and use other values than the actual amount I bought the item. Now, they have that power, but in implementation, the devil is in the implementation. So I agree that some maybe the short answer should be, come and see me, come with a fee note, come with some fees. No, but it's something that can be looked into, and we do some bit of pro bono work.
Yes,
we do some bit of pro bono work, corporate social responsibility. I think it's a question that we can look into and get the facts, because it's I don't believe in passing judgment without full facts. I don't want to fall in that category where I would just pass judgment without looking at the full facts. But it's something that we can look at.
Yeah, I think he can maybe tell us the website where he gets phones at half the price that are clear. Now I'll come to some in the room, but before that, we have a number of other questions and comments, but I'll just read out two. One is from someone called Black Chinese, and Black Chinese believes that the Chinese question was an intended bullet against the Chinese, but they are going to take that bullet on behalf of the Chinese. And I think the person who was asking, just so we are clear, wanted Uganda to have a double tax agreement with China. It was not a bullet, it was a flower. We have in the room Mr. Edwin Echiba of the Tax Hub, who is hosting an incredible platform about tax. And Oscar, I think you've been a guest at the Tax Hub, and he's hosting an incredible platform that's bringing together tax lawyers, and that's really creating a community of taxation lawyers. And it would be remiss of us, first of all, not to recognize his presence in the room, and then secondly, on behalf of everybody in the room, and I must tell you that the room has very many people. Some of them I think are from UCU, some of them are from KA, and some of them are from many places. I think the room is extremely full. People have come to spend their evening listening, and really we should have charged an entrance fee. But please allow me to, on behalf of everybody in the room, but also really on behalf of the massive tax professionals, that a generation of tax lawyers that you have inspired, allow me to hand over to Edwin so that he can fire away his question in under 1 minute.
Thank you very much.
You also need a phone.
Is that okay?
Thank you very much, Elison. And I also want to express immense gratitude to the Judicial Services Conversations for such candid discussions. It's good to see that tax professionals, I think after hosting Ms. Stella Nyapendi, a member of the Tax Appeals Tribunal, today we have Dr. Kambona. It's good to see that tax guys also dominating this space. So, and I think, like you rightly put it, we do host an event, and Oscar still, we also want to immensely express our gratitude. He graced our last nights, and it was very good to learn and feed off his illustrious career. So, Oscar, just one question to you. I'll make it two, but very brief. The very first is, Oscar, 30 years is no mean feat. You've lived such a very illustrious career. So many groundbreaking decisions you've had, mostly in the tax practice realm. I know you made mention of two decisions that you speak very fondly of, Rabo Enterprises and Talo, but also I think for the benefit of our colleagues out there, any other two groundbreaking decisions that you could have handled? We've read so very many, but any other two that are very close to your heart that you recall very fondly? Every litigator never forgets that, so I'd want to pick on any two that you do recall. Then lastly, Oscar, 30 years, such an illustrious career, one day you'll be gone. So my question to you is, how would you want Oscar to be remembered, from the academia to URA to the practice, now a doctorate, such a very befitting career, very inspiring. So how would you want Oscar to be remembered? That's on a personal note. Thank you very much.
Be at the Tax Hub night and to share. And the reason I like to participate, in such conversations, is that I believe that the best way to learn is to teach. Through sharing the knowledge you learn. So whenever I'm invited to such fora, I gladly participate. Not that I'm the only one with that knowledge, no. There are quite a number of people who in that knowledge, but it is also slightly selfish because in the process I learn. These several questions that came in this night, for example, are definitely going to go a long way to enrich some of my, my views. Now, to your questions, I'll start with the two other groundbreaking decisions I've participated in. Of course, you rightly pointed Rubble and the Tallow cases. There are cases, many cases I've been involved in, but some of them have been more or less repeating what the law says and affirming the position in earlier judgments. So nothing new as such, and quite a number fall in that category. But just two cases, and I've mentioned this before. One case that sticks in my mind is my very first case I handled in the Tax Appeals Tribunal. The very first case was by a company called Uganda Consolidated Properties Limited versus URA. Their dispute was about some sale of property. The company had sold the property and had not paid tax. And the reason they had not paid tax, they were arguing with the URA on whether there was a sale, whether the sale of the property was taxable. So when they come to me and we go to court, our argument was simple. You cannot charge tax when the law says if you sell land, there is no tax. The argument on the other side was you didn't sell land, you sold a building. But I had just remembered my land law at university, which was saying land and the building are all land. So I quickly told the tribunal the company sold land. They did not, yes, there was a building, but the building, what did they hand over? A title. LRV folio. And of course the court ruled in our favor. And the URA went and amended the law and clearly provided that the sale of undeveloped land is what is exempt. So for me that was good. It was good to learn that yes, you can use other areas of law to enrich your tax practice. That's one of those cases that come to mind quickly. Other cases that have been interesting. Yes, I mentioned earlier a case on import of services. And I'll mention another one, but I just want to reply this because I have mentioned it in another fora. They keep recurring in my mind because they were interesting in the way they were argued. This is a case by MultiChoice. It imports a service, and when it imports the service, the service is received in your house as elison. You switch on your TV, you receive the service. But the service is beamed from South Africa. The question is, who imported the service? Is it MultiChoice or elison? And my argument was that it is elison. Elison is this person who switches on, and in between there is no MultiChoice Uganda. It comes from there, it's beamed through the satellite, hands in his house. And my argument was, therefore, yes, there is tax. A service was imported, but who is the taxpayer? And the taxpayer was found by court to be the subscriber. So the question was, how is URA going to go to Elison's door, go to Rainer's door, and collect the tax? So that became a problem until they had to amend the law and say the one sending is actually the one.
The exporter is the importer.
The exporter is the importer, and they tried to. So there was amendments in that sense. But I also, in the course of my practice, had some cases that sort of streamlined the process, the procedural aspects of tax. One that stands out are issues to do with 30%, which we, in several cases in the compendium are there, where we were challenging the issue of 30%. And arguing that it can be paid at any time before the decision is made. Yes, so there are quite a number, but those I keep emphasizing those because they are not like these other cases where you are discussing bonus shares and the law is being interpreted either way, and the court makes a final verdict. Yeah. Now, last point, last question. How do I want to be remembered? I want to be remembered as that student of life, like I mentioned, who wants to contribute to the generation of knowledge in this country. I want to be remembered as somebody who, beyond the complexities of taxation, helped in simplifying. You know, there is a saying that I think it was Richard Brandon, who said that if you cannot explain something well enough, then you don't know it. So in these discussions, we are trying to simplify the little we know, and we are contributing to the knowledge. But if there is something I also want to be remembered, is a person who has advocated for courage in our practice. I have said it before, and I want to say it again. What is going to make the difference between a good lawyer, an upcoming lawyer, and a perfect lawyer is preparation, but also the courage to say no. You know, when I was at the tax night, when the session ended, a lawyer came to me and said that, you see, the problem we have is that we are overwhelmed. You go to a law firm, you are paid little money, but you are overwhelmed. You go home at midnight, at 6 you are back in the office, but you don't see the results. And my answer to that person was, please learn to say no. This word with only 2 letters can be the difference between success and failure. We are living in a culture where we fear to say, I am overwhelmed by work, can you pass it to someone else? Why? Because we fear to let down our people. To the young lawyers I'm talking to, we must learn to be candid. It takes courage to tell your supervisor, for example, that, you know what, I need to know your deadline. If your deadline is 2 days, I am overwhelmed. Can you give me 7 days? If not, find someone else. Sounds too rigid, but that is the reality. I can assure you, we have got instances where people are overwhelmed, people are exhausted, people are stressed. In fact, when I talk about being an addict of exercise, it's because one of the things I jealously guard is my health. I believe that, as the cliche says, health is wealth. I believe that if you do not have a healthy body, I can assure you your level of productivity will go down. So yes, I know I'm digressing, but these are some of the soft skills that I feel are important, especially for the young and upcoming lawyers. In addition, of course, to the mindset. the need to move away from a scarce mentality to a mentality of sufficiency. We need to have that sufficient mentality and leave the scarce mentality that there is little for a few. No. Tax practice and the head of Tax Hub needs to emphasize tax practice is on the rise. It can only grow bigger. Each company is a taxpayer. As URA continues to strengthen and broaden its tax base, many people are going to have to pay taxes. There are going to be people who want to pay willingly. There are those who want to say no. If there's something we are going to learn today is to prepare ourselves for that moment when it comes. Thank you.
Thank you. If you're just joining us, welcome to the Judicial Service Conversations. We are about to wind up. And I think Oscar, as the student of life who wants to contribute to this generation of knowledge, there is maybe just one last area that I'll take you in. I know we've overshot the time. Oscar, you've not just practiced tax law. You've practiced across a whole spectrum of law. If you go and read some of the most far-reaching constitutional decisions in this country, you'll find that you have actually argued them, including removing the issue of committal. You know, in the past in this country, when you were charged with a criminal offense that was going to be tried by the High Court, once you got bail, if you were committed, you would be remanded again. Your bail would automatically lapse. And Oscar took that particular provision to the Constitutional Court and told the judges that if the man has got bail, if he's presumed innocent, if he has not jumped his bail, why does a piece of paper change the status? Where is it constitutionally established? And actually, the remand post on committal was deemed unconstitutional, and Ugandans who are now charged no longer have to go to jail. I think there's also a decision on retirement, where somebody tells you to retire, and they tell you write a letter and retire, and from a public office. And when you retire, they tell you you've retired. I think you're able to get the court to say, my friend, a retirement is at its heart voluntary. And so you've been involved in very many criminal matters, civil matters, issues to do with shareholding. I think there was an issue, of bicycles, roadmaster bicycles. So as someone who has participated in the court, you told us just at the beginning about a decision that was determined in that a dispute that arose in 2013. At that time, there was no tax hub. In fact, Mr. Chiba was busy thinking of what to do with his life. But now the decision arose, it is still in the Court of Appeal for the judges to hold on. One of your good friends, Mr. Ali Sekatawa, who is also himself has a history in taxation and is now in petroleum, told us that he once got so angry with something, he came here and he filed a constitutional petition. After 10 years, he was called and told that he has won. And he couldn't remember what he had won. He couldn't recall the dispute. He said, what was I complaining about? They told him, congratulations. And he said, They said, you've won the petition. And he had forgotten that he had petitioned. In fact, he was looking for the alley that had won. So the question is, one of the big issues right now affecting court is jurisprudence. There's where you talk is backlog. There's where you talked about the Constitutional Court in Kenya being very busy because of the aggressive nature of litigation in Kenya. But in Uganda, I'm sorry, my lords who are listening, it's gridlocked. Now they tell you that, how can I say this without landing in trouble? Sometimes some of these judicial decisions are a bit like, was it Okonko's father, who was told to pay his debts and he drew lines in the sand and then lines across creating tables, and he said, you see all these small boxes, all the people I owe money. For you, you're the last one. I first have to pay all of the people above before. Justice has somehow become like that, and it has become like that because of judicial backlog. We have backlog in criminal and in civil cases, in tax matters, in land matters, in family matters. We've been proposing here on the Judicial Service Conversations for the better part of a year. We need to invoke Article 142.2 of the Constitution, get lawyers as what we call mission-based judges. We look, for example, at the example of the Tax Appeals Tribunal, where many of the people who serve on it are actually private individuals who are coming, and their backlogs are much shorter, and their speeds are much faster, and their achievements are much quicker. And we've been arguing that we need to scale. So what's your... I know you've been following this argument, so maybe... I know it's a very long question. In fact, it's actually an argument in the question. So I want to know your take. We had... Just to give you context, we had a guest recently who supported it very strongly. We had one who wasn't that enthusiastic about it. And we had Chief Justice Owunyidolo who was... He told us to convince him. So, and it takes 2 years on average to conduct a trial in this country. You go for 2 years and you're on remand. There are people on remand for 10 years. I could continue making the case, but you've had the case that I've made. Of course, I've made it to you, but now maybe you can give us your view on that.
Yes, a long question, because in there you mentioned my very good friend Ali Sekatawa. Yeah, we share a lot. We used to fight when he was the commissioner in charge of litigation in URA. But definitely we go a long way, and I really respect him. The crux of your question is really about the judges, part-time judges.
Yes.
As a solution to backlog. Sometimes we are addressing the symptom, not the cause. And I think I've not read the reports, but we need to step back and ask ourselves what is causing backlog. Have we addressed the causes before we now address the backlog itself? I think there's need for debate in that context. But I think the short answer is that I think yes. Anything that increases on manpower, for me, is welcome. I always believe, and I've mentioned this several times, that success is 20% skill and 80% strategy. 20% skill and 80% strategy. You may be a very good lawyer, a very good judge, but there must be a strategy to address this backlog. One of them, technology. For example, technology. The tribunal has, the Tax Appeals Tribunal is doing a commendable job in that respect. I mean, so these adjournments and etc. are done online. You don't have to go there. Sometimes even witnesses, I've had witnesses in the tribunal in the US, they don't have to come here. Then they've testified. And it has gone on. I mean, rather than 3 days of travel, the man gets here, jet lag, give him 2 days, he comes here, there's an adjournment, he goes back. You just do it online. That may help. But the point I go back to is the cause. I'll give an example. A tax dispute, if the law is amended to say that a dispute after an objection decision, if the case goes to the Tax Appeals Tribunal, it must be resolved within 6 months. And that is the law. And the rules then provide that you can only ask an adjournment for 3 days. That will change things. Sometimes the laxity, the ability to read into adjournments in itself can be a problem. I must admit that we as lawyers, as litigants, and even our clients, sometimes we come with different objectives. Sometimes they're buying time. The man tells you, just go, argue your case, but stay there because I'm still organizing my accounts very well. I'm not saying it's happening. I've not had some come to me in that. But the point I'm trying to say is that the cause, some of these, the laxity within our rules. And I think in terms of numbers, there's been an effort by the Judicial Service Commission to recruit lawyers, judges. But is it enough? And I think no. Maybe the part-time judges may help. It may help in terms of give them assignment and give them time. The problem, some people will tell you, I've had arguments, people will say, justice needs not to be rushed. Sometimes you bring an injustice. But I'm telling you, there is an appeal process. If the judge in the lower court got it wrong, the Court of Appeal will correct it. The Supreme Court will correct it. Where you are give a judgment. And I think, of course, it's in our interest as lawyers. Faster justice means more productivity. I don't think a case which takes 5 years in a court increases your charge out. You have negotiated the fees. In most cases, they have paid you. You've asked for advance. The money is finished, but the case is not resolved. Yeah. So yes, I buy the issue of part-time judges. I buy the issue that it can help. But I also say, let's go back and address the causes. Let's have a think and a look into the causes. Thank you.
Now, Oscar, there are so many people who are asking questions. And I will only read out the comments from Ken and of Oscar Kambona School of Taxation. Such knowledge should be celebrated and transferred to the next generation. This is Mr. Ken Agaba who says that as a nation we need to think of the Oscar Kambona School of Taxation. Such knowledge should be celebrated and transferred to the next generation. This could be engineered by KA itself or MAC. It's my small thought. The team can expand it. I think, Ken, we have expanded it by hosting Dr. Kambona on the Judicial Service Conversations. There are many other comments, I think, and a lot of positive comments. More than 40 comments now. We are seeing people who are really grateful for the time that you've spent with us, and a large number of people have tuned in to listen to you, and we had promised you that we'll be done by 9. But there were no objection. There was no objection. There were no objection proceedings here. There were no assessments involved. There was none of that. What we have is gratefulness. So we are going to wind up. How we usually wind up is I give the parting shots. But before I give the parting shots, I'll give you a chance to give your parting shots, Oscar. And in your parting shots, I want you to just look at to give us your parting shots, your closing thoughts. You have before you a generation of Ugandans on the Judicial Service Conversations. The vast majority of our listeners are non-lawyers. You have a generation of young Ugandans, many lawyers, many non-lawyers, many law students, many judicial officers, but a vast majority of them are members of the public. What would be your parting shots to them be? Now, Oscar is also, what we forgot to say, apart from being very healthy, is also a reader. You like books and new things and books. So if you could tell us, this is usually Joy's question. I stole it from her. If you could tell us, and we don't usually tell, and we didn't tell you, what books you're reading, what books you'd recommend for people to read. And then, we've always been ending with a song. And that song has always been targeted at members of the Uganda Law Society. And the song was always, Oli Mujawa, Musaja Singanze. But, I have been advised here by the younger lawyers that really I should stop those bad manners. And what we want to do is to offer you the opportunity. What kind of song would you leave us with? What kind of vibe would you leave the listeners here with? So if you give us your parting shots, your books, your vibe, then I'll give the parting shots, and then our resident DJ, the youngest lawyer here, will find that song. He can find any song. He's like YouTube.
I think my parting shots are informed by something I also value so much. I value gratitude. I believe we must appreciate even the small things and say thank you. In fact, in the Bible, there were 10 lepers who had problems, cast from the community. They cried out to Jesus. Jesus healed them, free of leprosy, which was not curable. Only one came to say thank you. And he asked, weren't you 10? Where are the 9? So for me, with that background, I always want to appreciate even the small things, even the small opportunities. So let me appreciate this opportunity to be part of the discussion, this honorable forum, the Judicial Service Conversations. I want to thank you for what you are doing towards enriching knowledge in various sectors. When you call practicing lawyers, when you call judges to this kind of fora, you are enriching knowledge. Why? Because knowledge has got two aspects. There is what we call experiential knowledge, and there is what you call intellectual knowledge. There is the knowledge you go and study in class, but also there is the knowledge that people lived experience. And practicing lawyers, practicing judges, the community who are out there will give you that experiential knowledge. Some of the things that you will discuss in such fora are things that you want to go to law school and study, not even at LDC. What I would call soft skills. I am a person who believes in networks. I believe that as lawyers, we must always focus on 3 things: on our networks, on building trust, and finally on enhancing knowledge. Acquiring and enhancing knowledge. Very important, what I would call the soft resources. The other resources like money, staff, and etc. you can whatever, but these are things that are within. Networks, the people you meet, people you interact with, have a role to play. So, yes, I am thankful for this opportunity. I don't take it for granted. I am here with very senior lawyers. To have Elson in front of me the whole evening when the man is preparing for the Katanga case tomorrow. Yeah, I mean, I don't take that for granted. So, first and foremost, my parting shot is thank you. I said the same point to Tax Hub, and I think for me the pledge is that whenever I'm called upon, I'll be available. Books. What books are you reading? We read very, very interesting books, but most of them revolve around understanding who you are. Most of them revolve around personal leadership. Some of the books we have been reading lately are what you call classics. Simple classics. The Power of the Subconscious Mind. The mind, the subconscious mind, has a big role to play in our lives. We are only scratching the surface. In fact, those who understand the subconscious mind relate it to AI that we're talking about today. Because the subconscious mind is the storage of memory and everything, and it's the creative side of things. So we read various books, but if there is a book I want to recommend that has made an impact, I have read it many times and before, is the 7 Habits of Highly Effective People by Stephen Covey. That book will tell you things to do about personal management, personal growth. One thing that sticks out in that book that I always remember is the power of keeping this most important thing the most important thing. Keep the main thing the main thing. The point in that book that talks about time management, I can assure you we struggle as lawyers to appreciate what time management is. And that book, for example, breaks it down. Can you have things that are important, not urgent? Things that are urgent, not important. There are things that are not important and not urgent. If you do that matrix, for example, I can assure you your time management skills will improve. One of the most important things that is not urgent is relationship building. The other thing is critical thinking. The other thing is strategic planning, preparation. These are things, these are skills that we rarely talk about. But these are things in these books. I believe that reading is important for us in our generation, in this generation, because we don't have to reinvent the wheel. We don't have to repeat the mistakes that our parents did. These people, especially the whites and Ugandans, are beginning to write and put everything in writing. But people, especially in the what you call the developed world, the Western world, have mastered the art of sharing their experiences. Stephen Covey is long dead, but we are still relying on things he talked about. First things first. Be proactive. The last point on that, on books, is about decision making. There's a book I read by Jeff Bezos. He's in his book, he says he only makes 3 decisions in a day. This is among the richest men. Makes only 3 decisions. And he makes sure that those decisions are backed by facts. The decision of what I will put on for today is not a decision he will make, because he knows my attire is this. But sometimes we may spend 30 minutes deciding what you're going to put on. It takes time from you. Can we focus on those small decisions? Can we make those decisions? Can we make prompt decisions? And if we make those decisions, can we stick by those decisions? I have had situations where people have made decisions and the next day they are changing their decision. You see, they are withdrawing their decision. No, make your decision, stand by it. If you believe in it, whether right or wrong, stand by it. Stand by the decision. Of course, they are life-changing decisions. But again, like I'm saying, this is all in saying there is a value in reading. Like I said, I'm part of a book club, and one of the things we enjoy in that book club is that we sometimes disagree with what is written in these books. We challenge them. Because one of my values is to be intentional. And in being intentional, I must ask myself the question, why? You want me to come and be on the judicial service conversation? Why? What's the intention? Are you just doing it for the sake of it, of ticking a box? Or are you doing it to enrich? So these books have encouraged in me the need to question. Ask myself ask why. Sometimes I like to say you must also reach a position of questioning the question. Question why? Why? But finally, are you listening? When you ask that question, are you ready to listen? Are you ready to receive feedback? When we come to this meeting and we spend hours here and go to bed late, and we have received all these ideas, some you would agree with, some you may disagree with, are you listening? That's the question I leave with you. So the song. Yes.
Yes, the song.
I love local artists.
Yes.
I love reggae music. But today, I want to live something called love.
Yes.
I want to live something called love. Love is very, very important.
I agree.
Love is very important. By the way, in life there are two emotions. We are born with two emotions. We are born with the emotion of fear
And of love.
and we are born with the emotion of love.
Yes.
Transcending your life limitations means that you will suppress fear and enhance
Love.
love. And it is love that I live with you in a song called Perfect.
Perfect.
Ed Cherison. Perfect is my song. Thank you.
You've heard it here. If you're just joining us on the Judicial Service Conversations, we are talking about love today. And you're late. I'll just read one comment and then make my parting shots. I think this is a comment from one of our organizers, Mr. Ferdinand. He calls himself the son of Loyola. Of course, Oscar, you know him well. He says today's discussion is an entire thesis on taxation in Uganda. Can we ask Makerere to give Dr. Oscar Kambona another PhD? Then he says, I don't know what problem he has with this person, but he says he has ably defended his thesis, unlike Faith. Now, we shall deal with Faith later, but I think my parting shots are quite simple. Colleagues, you have heard. Are you listening? Because tonight we have had the rare privilege of listening to a lawyer who has spent a lifetime thinking about the law, changing the face of practice in this country, and practicing especially in a complicated area of taxation, but in the general areas of the law. And what Dr. Oscar Kambona has reminded us this evening is we are not talking about numbers, we are not talking about assessments, we are not having clever talks of people coming here and giving us nice big words, but he's given us talks about relationships between the citizen and the state, between the advocate and the client, between the taxpayer and the tax authority. He has told us about life, about practice, about planning. Oscar has tonight has shown us a practitioner who has not just argued cases, who is not just a practitioner who has argued or advised clients. He has come here today and he has spoken to us as a practitioner, as a teacher, as a student, as a scholar, as a philosopher, as a reader, as a health guy, as a book guy, as a law guy. I mean, they are talking about a second PhD, but I think maybe a third, a fourth, a fifth, and a sixth should just be given. My brother Nicholas Opio likes commenting about honorary degrees. So I say, there's a problem with these honorary degrees, but I think Oscar now on top of his PhD, we should give him an honorary PhD as well. Colleagues, you've heard the voice of a lawyer who understands the necessity of taxes and the limits upon which enforcement should be done. Everybody who has joined us this evening, I'm sure, has left much better than they found us. You have helped us to cure a huge amount of ignorance in some of us. A huge amount of ignorance in some of us, in many of us. And and this, colleagues, is what the parliament of the bar is. But I was told that bars have parliaments. This, colleagues, is what the parliament of lawyers is. A place where we can come together at this fireside of the profession, reflect and debate the great questions of our time. But most importantly, Oscar has told us about love. And he has left us with a song about love. The DJ should play Ed Sheeran's